Rogers, and I'm a staff attorney at the Sexual Assault Legal Institute. I'm presenting today on money matters, credit restoration, debt, and bankruptcy. So the Money Matters project focuses on the financial impact sexual assault has on survivors and examines economic empowerment of survivors. Sexual assault has serious financial costs to survivors that can impact their ability to achieve financial stability in the long term. This goal is to increase financial stability and security for survivors, and that is supported in part by educating attorneys and advocates about legal remedies available to support a survivor's financial independence. Our objectives for today will be to identify and discuss strategies for restoring credit for survivors, identify consumers' rights in debt collection, learn about survivors' rights, responsibilities, and the process for bankruptcy. As always, some of our core reminders: the law is always changing. Always check the law for the most up-to-date information. Whenever you are asking for financial relief for a survivor, check to see if financial statements are required and when they must be filed. A survivor's immigration status can impact what options are available. Always check eligibility requirements before advising undocumented clients. With torts, tort suits may not always be an option, but when available, they can hugely impact a survivor's financial stability. Tort law has difficult statutes of limitations and is changing for child sexual abuse cases. Attorneys must advise survivors about available torts and statutes of limitations. Available torts can include assault, battery, conversion, and child sexual abuse. As a note, recently, Senate Bill 686 and House Bill 1 in Maryland has repealed the statute of limitations in civil suits based in child sexual abuse and allows that law to apply retroactively, and this went into effect October 1st, 2023. So first of all, it's important that we talk about financial abuse and how this is related to survivors' issues. Sexual violence can have economic impacts on survivors' lives, and one way is through financial abuse. Financial abuse consists of behaviors that an abuser can use as a means to assert power and control. This can include preventing a survivor from working, taking their paychecks, limiting their knowledge or access to finances, through coerced debt, which is defined as using force or threat of harm to force a survivor to take on debt they would not have taken otherwise, or through identity theft, which is using a survivor's personal information to take on debt or fraud. A vital part of healing a survivor's financial health is restoring credit. Credit and credit reports affect every aspect of our lives, and bad credit can impact a survivor's ability to achieve financial stability. Credit reports compile a consumer's personal information and credit history, and this is viewed by potential employers, landlords, insurance companies, lenders, and other creditors before deciding whether to extend credit to a consumer or rent an apartment, among other activities. The first step towards financial independence and stability is developing a plan. Credit reports are used when a consumer applies for a loan, credit card, mortgage, or any other type of credit. Additionally, some employers check credit reports as well, but Maryland's law has limits as to how those credit reports may be used. Under the Job Applicant Fairness Act, employers cannot use a credit report to deny employment, discharge an employee, or determine compensation, conditions, or terms of employment. However, employers can use a credit report for any other purpose after extending an offer of employment. Another caveat is that employers can use credit reports if there is a substantially job-related reason for doing so, but the applicant or employee must be informed in writing. The first step towards credit restoration is meeting with the survivor to discuss their goals, their credit, and their history of victimization, including the time period. You will want to identify whether any debt has been incurred was through coercion or through fraud. Identifying how that debt was incurred allows you to create a plan towards restoring a survivor's credit because how debt was incurred can affect your plan moving forward. The next step is to pull credit reports from the 3 credit bureaus, Experian, Equifax, and TransUnion. It is best practice to pull from all 3 bureaus because creditors can sometimes report information to one bureau, but not the others. Anyone is entitled by law to 1 free credit report from each bureau per year. From here, you and the survivor should identify any unauthorized charges or inaccurate information in the report. So what actually appears in a credit report? In that credit report would be names and any aliases, social security number, a date of birth, current and past addresses, phone numbers, current and past employers, credit and loan accounts such as mortgages, vehicle loans, personal loans, student loans, or credit cards. A report can also include information on credit and loans, such as the amount of credit that was extended or loaned, the date that that was opened, payment history, and account balances. Additionally, collections accounts, meaning any unpaid debt that is transferred to a collection agency by a lender, can also appear. Unpaid child support or alimony would also appear on credit reports, and any bankruptcies would appear as well. There is other information that credit bureaus take into account, but per practice are not typically included in the credit report itself, such as a criminal background. There are time limits that dictate how long certain information is allowed to appear on a credit report. These time limits vary by the type of information, and they cannot be included after that time period. For bankruptcy, any bankruptcies declared would only be able to appear on that credit report for up to 10 years. Suits and judgments, paid tax liens, collection accounts, criminal records if they're included at all, and any negative credit information can be included for up to 7 years. Under Maryland law, these time limitations do not apply when a credit report is used for any credit transaction of $50,000 or more, life insurance for $50,000 or more, and employment where salary would be $20,000 or more. If there is incorrect information on a credit report, that should not appear either due to time being elapsed or information that is inaccurate or just should not be there in general, the consumer has the right to correct that report. To do so, you must send a dispute letter to the credit bureau or bureaus that reflect that incorrect information, who then have a duty to reinvestigate and, if applicable, correct. Reinvestigation must occur within 30 days of receiving the dispute letter. The consumer's credit report must also include a note that the consumer disputes the information and include the dispute letter or an accurate summary of that letter. If after reinvestigating, the Bureau determines that there was an error, they must remove the information and supply written notice to the consumer and each person that that inaccurate information was provided within 7 days. Per request, the Bureau will also provide notice to any person that had requested a consumer's report. For any report that was requested for employment purposes, that goes back to the last prior 2 years, and for the prior year for all other purposes. The creditor, you can also send a copy of the dispute letter and any supporting documentation to that creditor as well, who also has a duty to correct information. This ensures that a creditor has accurate records. In cases of identity theft, certain steps must be taken to dispute fraudulent charges and begin restoring credit. One way to do so is through credit freezes and fraud alerts. A credit freeze restricts a credit freeze, also known as a security freeze, means that access to a consumer's credit report is restricted. So lenders, creditors, and others cannot view a consumer's report. This also means that the consumer or others cannot open a new credit account during a freeze. However, a consumer can request to temporarily lift that credit freeze in order to obtain credit if necessary. A fraud alert, on the other hand, is an alert on a consumer's credit report to make it harder for someone to open credit in that consumer's name. Generally, once the alert is placed, businesses must verify the consumer's identity before issuing credit. Credit freezes are useful after identifying any unauthorized charges, especially in cases where there is suspected identity fraud. You can request a credit freeze for free if the consumer had not previously requested a freeze, or if they are reporting identity fraud. A credit freeze prevents creditors from seeing that information on the report. A submission can be done electronically, via certified mail, or over the phone, but some sort of form of written request is best practice. You may also need to provide certain personal information to verify that consumer's identity, such as a social security number, a birth certificate, driver's license, or other government ID, or a utility bill. In cases where there is identity theft, you should request a fraud alert and a credit freeze with the credit bureaus. An extended alert can last for 7 years. You will also need to file a police report, as the Bureau requires this in part for disputing fraudulent charges. Be sure to request a copy of any filed police report. It's also good practice to file an identity theft report with the Federal Trade Commission as well, as this can also be used in disputing any fraudulent charges. You should provide police or Federal Trade Commission reports to the credit bureaus when disputing fraudulent charges. From here, review those charges and again, include disputes in writing by providing a dispute letter, those reports, any supporting documentation you have, and personal information to verify identity. You should also request the removal of fraudulent information and request that the credit bureau cease reporting that information. In some cases, a consumer can submit a statement to credit bureaus to explain any negative information in their credit report that cannot be removed. This is especially helpful if the disputed information remains on the report after a reinvestigation. If it is accepted and included, the statement would be visible to any landlords, employers, or any other parties that look at the consumer's credit report. Practically speaking, be sure to request that that statement is removed from a credit report once the negative information is no longer included, so that any parties that review in the future would not be put on notice of past issues. Some examples to explain negative information would include providing any facts to explain circumstances for negative information and any steps being taken to correct. For instance, I was late on this payment because my partner had forced me to stop working by threatening me and told me that they would take care of finances. I had no idea they were not paying. I am working again and working towards making payments. So the actions being taken and an opportunity to explain the facts surrounding that negative information. Another useful part of explaining information is if a consumer disagrees with an investigation's outcome. This is another outlet for a consumer to express that they disagree, provide those facts, and again, steps that are being taken to correct that information or remedy that information. Additionally, another way to bolster someone's credit report is to include a history of positive unreported payment history. This can be achieved with any sort of positive payment history that that consumer may have, for example, with a landlord or a utility company. The consumer can ask for letters of support from these creditors, and they can also ask these creditors to report that positive information to the report as well. As far as credit counseling, some survivors may pursue credit counseling to help restore their credit. A good company can help create a plan to repair credit, while a less trustworthy company may appear to have good intentions, but in reality is a scam. Per Federal Trade Commission and guidance, Here are some ways to help identify if a credit counseling company or counselor may be a scam. Credit repair companies or counselors that insist on payment before helping the consumer, if that consumer is told not to contact credit bureaus directly, if they're told to dispute information they know is accurate in a report, if they're told to lie on applications, and if they don't explain legal rights to a consumer, these are all signs that something may be a scam. Per FTC guidance as well, reputable credit counselors or companies will look at an entire financial situation before formulating a credit plan. They'll also explain legal rights and services in a written contract, and a consumer will not be required to pay money up front before doing any services. Some best practices, if you are assisting a survivor with restoring their credit, are to have that survivor sign a release of information that gives the credit bureau's consent to communicate with you. You should also encrypt emails when sending personal information, and it is best to have a written paper trail. Excuse me. So any requests are in writing and have certified mail return receipt. You can also request that emails or written responses in writing from a creditor or confirming from a credit bureau to confirm that information has been removed from a report. You can request for those in writing. It's also good practice to pull a credit report 30 days after an item is said to have been resolved, just to ensure that it has indeed been removed from a credit report. At this point, we'll be talking about debt and rights with debt collectors. Consumers are entitled to certain rights when dealing with debt collectors and with creditors. Debt collectors are subject to both federal and Maryland law. Federal law imposes restrictions on debt collectors and debt buyers that they must follow. The right to request in writing that a debt collector stops contacting the consumer. Excuse me. A consumer has the right to request in writing that a debt collector stops contacting. However, this can change with creditors. A consumer can request that a creditor ceases contact, but they are not required under the law to stop contact. There are differences between debt collectors and debt buyers that are important distinctions. Debt collectors include collection agencies, an attorney, a creditor collecting on someone else's behalf, and a creditor collecting under another name. A creditor that collects for themselves is not considered a debt collector. A debt buyer, on the other hand, is a company or individual that buys debt from creditors to collect debt themselves. This is an important distinction because there are certain rights that consumers have with debt collectors. Under federal and Maryland law, a debt collector is forbidden from performing the following. They may not call before 8 a.m. or after 9 p.m. They may not call, write, or visit at work if the employer forbids it. They cannot contact the consumer after a written request. They cannot inform others why the collector wants to contact the consumer, trick, lie, or use bad language, or call too much, contact the consumer directly if they're represented by an attorney, use or threaten force or violence, threaten criminal prosecution unless there is a violation of law, and contact an employer before there is a final judgment. A consumer can dispute a debt in writing if they believe they do not owe the debt that the collector is contacting them about. They should do so by sending that through certified mail with a return receipt. And if done, the debt collector must respond with why they believe the consumer owes that debt, providing information or other documentation. If there are any violations of law, it's best practice to advise the consumer to keep a journal logging the date, time, name, the telephone number, and what was said on the contact. A consumer can file a complaint for violations either federally or under Maryland law by contacting the appropriate department. For violations of Maryland law, the consumer can contact the Maryland Attorney General Consumer Protection Division And federally, they can contact the United States Consumer Financial Protection Bureau. There are different rights with unsecured creditors. An unsecured creditor means someone who loaned money without asking for collateral first, meaning the consumer did not have to offer up any property or other assets in order to get the loan. A creditor can send debt to a collection agency or file a lawsuit. A creditor may also offer a payment plan agreement to the consumer, but the consumer does not have to set up a payment plan, especially if they cannot afford to make payments. If a creditor files suit and wins, they can ask to garnish wages, garnish bank accounts, or ask to sell the consumer's personal property. Garnishing wages means that the employer would pay part of that consumer's wages to the creditor. However, no more than 25% of wages can be garnished, and wages cannot be garnished if those wages are less than 30 times the minimum hourly wage. Bankruptcy is a legal process for seeking relief, and sometimes bankruptcy can be the best option for a survivor to help discard debt or make a plan to repay debt. This can be especially important for survivors that have experienced financial abuse to become financially free from their abuser and make a fresh start financially. Individuals can file under either Chapter 7 or Chapter 13, and bankruptcy is under a federal bankruptcy court and follows the bankruptcy code. Chapter 7 bankruptcy allows individuals to discharge debt. Generally, this is a quicker process than other bankruptcy proceedings. A Chapter 7 bankruptcy would appear on credit reports for up to 10 years, and it can affect someone's credit score as well. Filing Chapter 7 bankruptcy is generally appropriate for an individual that has little assets or money and has trouble meeting their basic expenses. Additionally, there are income limits in order to be eligible to file Chapter 7 bankruptcy. Chapter 7 bankruptcy entails selling certain property, and that money from those sales, called proceeds, are put towards creditors. However, there are some exceptions under the law for property that an individual is allowed to retain. Under Maryland law, those exemptions include any court-ordered child support that they are being paid, tools needed in a trade up to $5,000, any prescribed health aids. You are allowed to retain equity in a home that you own and reside in, cash or property up to $6,000. However, that must be claimed within 30 days of a levy attaching. Any household furnishings and goods up to $1,000. Personal property up to $5,000. Public benefits. And additionally, there are wage exemptions by county. Chapter 13 bankruptcy is another type of bankruptcy that someone can file for. And under Chapter 13, rather than discharging debt, individuals develop a payment plan to repay all or part of their debt. Process is longer, generally about 3 to 5 years, and Chapter 13 also appears on credit reports for up to 10 years and can affect credit score. This form of bankruptcy is appropriate for an individual that has income to meet their basic expenses. In Chapter 13 bankruptcy, the court sets up a payment plan, and the individual can retain their property as long as payments are being made. For bankruptcy, when we are talking about discharging, that means there is no obligation to pay those debts. However, certain debts cannot be discharged through bankruptcy. Debts that cannot be discharged would be any alimony, child support, debts that were not listed in the bankruptcy filing, any student loans with an exception for undue hardship, a court or administrative order for damages, fines, penalties, or citations, debts obtained by false pretenses or by fraud, debts due to injury or death caused by driving under the influence, income tax, and general tax. Once an individual files for bankruptcy and their petition is processed, the court issues something called an automatic stay, meaning that creditors are banned from contacting the individual and they must cease all efforts to collect that debt. Before filing, the individual has to enroll in credit counseling from an approved credit counseling course within 180 days before filing. You also need to have filed a tax return for the past year before filing. There is also generally a filing fee. However, there are income waivers if filing for Chapter 7 bankruptcy. Bankruptcy proceedings are under the exclusive jurisdiction of the U.S. Bankruptcy Court, meaning an individual has to file specifically in a federal bankruptcy court, which is a separate courthouse and system from other courts. Because bankruptcy is specialized and specific, only a bankruptcy attorney can assist an individual with filing. In Maryland, there are 2 bankruptcy courts and are county specific. So the county you live in determines which court you file in. Specifically, in Maryland, the bankruptcy courts are in Greenbelt and Baltimore, and the counties that would apply for each are listed here as well. At this point, I'm happy to take any questions that anyone has. And if there are no questions in the meantime, this is an ongoing series of our Money Matters series that includes our economic empowerment for survivors, amongst other Money Matters training programs. We also are launching a webpage with additional resources. If there are any questions, I am happy to take. And if you think of questions for after this webinar ends, feel free to email me on this screen. My email is listed here, and I'm happy to answer any questions that folks may have.
Thank you so much, Sam. I would like to direct everyone's attention to the chat. I posted the evaluation form there. We appreciate all feedback that you provide as you're constantly striving to improve our training programs. Also, if you're seeking certificates of attendance or CEUs, you'll need to fill out the evaluation form. And again, as Sam said, if you have any follow-up questions or additional questions, you can go ahead and contact her with her email address on the slide. Thank you so much for joining us.